Cardozo formed the FAME Center, which is Fashion, Arts, Media, and Entertainment, including sports. And after several decades as a lawyer in the fashion world, I became the director of FAME, and I'm also a professor of practice here at Cardozo. FAME provides training and development opportunities related to the representation of businesses driven by the creative process, from Fortune 500 companies to startups. We offer coursework, like the course I teach on fashion law. We have courses on sport. The head of the General Counsel of the National Hockey League teaches sports law here. We have art law. We've got entertainment law, and the list goes on. Art law.
Recording in progress.
We offer externships, clinics, symposia, and programs featuring industry leaders, like this program tonight. Our alumni work in all major areas of the FAME world. I'm regularly making the Billboard's list of top music lawyers. We're working at all the major motion picture studios, streaming services, sports leagues, the art world, and the list goes on. FAME hosts weekly programs like this program tonight. We had Steve Madden here last week, which was wonderful and hilarious. We hope you'll join. If you enjoy this program, I hope you will join our mailing list. Our programs are free, as you know, and they offer almost always, CLE credits. Our moderator, Leslie Saltzman, and other panelists, including Rebekah Diller, are co-directors at Cardozo's Tzedek Legal Services Clinic. And they came to me to talk about cross-cultural things here. They came to me 2 years ago with the idea of doing a panel on conservatorships as they related to Britney Spears. And I, being 75 years old, said, why should I care about Britney Spears? And I quickly Googled what was going on with her and her father. And we had an extraordinary program with, I think, 200 attendees, because people were really interested in that topic. On a personal note, both my mother and my husband were candidates for conservatorships, and what I've learned from Rebekah and Leslie encouraged me not to go that route, and I'm very glad that I made that decision. They each reached out to me and said, when the time came, I'm ready for me to take over financial affairs and the like, but this is a really, really important topic, and you youngsters will be dealing with this when you're our age, dealing with husbands and wives and partners and parents. So I'd like to introduce the student heads of our Entertainment Law Society, Kevin O'Hara and Sydney Grant, head of the Sports Law Society, who will introduce our speakers and take it from there, and I hope you enjoy the program.
Hi, I'm Sydney. I'm president of Sports Law Society.
And hi, I'm Kevin, president of the Entertainment Law Society.
We just wanted to welcome everyone to our first event of the semester, and we hope you come to more of our events. We also just want to thank our two guest speakers who came in today, Mr. Carroll and Mr. Romano, for coming, and also the FAME Center, for especially Barbara and Anne for putting this together, as well as everyone else who was a part of it through the Cardozo administration.
I'll now introduce the moderator for this evening's discussion, Professor Leslie Salzman. Professor Salzman is a faculty member of Cardozo's Kuchen Program for Conflict Resolution and is co-director of Cardozo's Tzedek Legal Services Clinical Program. The clinic represents low-income individuals in matters relating to public and private disability and health-related benefits and insurance, housing, and consumer transactions. During her time at Cardozo Law School, Professor Salzman has been involved in individual and class action litigation involving rights under the Constitution, Americans with Disabilities Act, Social Security, Medicaid, and Medicare laws, the Federal Housing Act, and various consumer protection laws. Professor Salzman is trained as a community mediator and serves on the mediation panel of the Southern District of New York. Prior to joining the Cardozo faculty, she served as an attorney at New York Lawyers for the Public Interest, as well as South Brooklyn Legal Services. Thank you for leading the discussion tonight, Professor Salzman, and let's give them one more round of applause.
Thank you. So hi, good evening. I'm going to
quickly introduce the speakers, and my colleague, Professor Rebekah Diller, co-directs the Tzedek Clinic with me, and you heard a bit about the clinic and the kinds of work we do. We try to advance the rights of older adults and individuals with disabilities through federal and state court litigation and administrative proceedings. And Professor Diller's scholarship and her litigation has focused on the rights of people under guardianship, elder financial exploitation, and problems of disability-based discrimination. Notably, she started the guardianship clinic that existed at Cardozo for many years, where she represented older adults in guardianship proceedings. Here in New York, we call them guardianship proceedings. In Tennessee, they're referred to as conservatorship proceedings. So Professor Diller had started that program, and a lot of the focus of that program was on developing alternatives to guardianship. Prior to joining the faculty of Cardozo in 2011, Professor Diller was the deputy director of the Justice Program at the Brennan Center. Our next speaker will be Domenic Romano, who's a managing partner of Romano Law, which he created in 2003. So he is a self-described lawyerpreneur, okay, and a corporate and entertainment lawyer with a practice that includes business, employment, media, and sports law. He has an active practice advising clients on business structuring, business divorce, purchase and sale of businesses, litigation, licensing, esports, film finance, and complex contract negotiation. He's a frequently invited legal commentator, and he appears on numerous networks and in various media outlets, so you might recognize him. And if that wasn't enough, he's a marathoner and a serious consumer of pizza. Okay. Keith.
That part is true. That part is true. That's the true part.
Keith Carroll is a trial attorney at Holland and Knight, where he co-chairs the firm's sports industry team. His practice focuses on complex commercial litigation and closely held company business disputes. He regularly advises senior executives, athletes, franchises, and prominent professional sports leagues, including Major League Baseball, National Hockey League, and the National Basketball Players Association. And he advises them with regard to internal investigations, business disputes, and other sensitive and high-profile matters. So those are our wonderful panelists. And before we begin, I just want to take a minute or two to give you a short overview or framing to set the stage for the panel's discussion. So most of you are familiar with the basic outline of the relationship between Michael Oher and the Toohey family. Some of you have read the book, The Blind Side, which came out in 2006, or saw The Blind Side, which won an Oscar for
Sandra Bullock won the
Bullock,
Oscar.
of course. Okay.
And for Best Picture.
And for Best Picture.
Okay. So what do we have here? We have a poor black teenager who was in foster care, who's taken into the home of a wealthy white Tennessee family that calls him their adopted son. The teen has a great career in college football and becomes an NFL football star. So the story appears to be a classic win-win, everyone is happy, and that was what we knew. Then comes August of 2023, when we learned more from a dispute that came into the media and was played out in part in the Shelby County Probate Court. So what did we learn? We learned that Michael Oher was never actually adopted by the Tuohys. We learned that in 2004, when Michael was 18 years old, the Tuohys filed a successful conservatorship petition, and that the court gave them the right to make contracts, enter into contracts on Michael Oher's behalf, and to make all decisions regarding his medical and educational affairs. So those rights were given over to the Tuohys. The Tuohys claim that a lawyer told them that a conservatorship was the only legal vehicle that was available that could help them enable Michael to go to college and participate in college football. And we'll hear more about that because it's maybe not as unusual as it sounds, okay? So what we see is this conservatorship is imposed in 2004, and we don't hear anything, nothing happens until August of 2023. But we have a conservatorship that was imposed on an adult who had no disabilities, and when Michael Oher sought the termination, it was quickly granted by the court, okay? And we'll hear about whether that should have been imposed in the first place. But what's most shocking is when you look at this is a case, a 20-year-old case. When you look at the file, the court file, you see a couple of filings in 2004 and absolutely nothing else until August 2023, which means there's no reports, no accountings, nothing. Okay, it just went into the abyss. But the conservatorship has now been terminated, and there is a big dispute going on. And Michael is claiming that the Tuohys tricked him and exploited him and failed to pay him his share of payments relating to book and film deals. And the Tuohys claim that when Michael's NFL career ended in 2016, he began demanding money from them and ultimately tried to buy his silence by paying him $15 million. I don't know where the truth lies. Oher is now asking the probate court to direct the Tuohys to provide a proper accounting, to pay his share of book and film payments, and seeking other damages, and they want to prohibit the Tuohys from using his name, image, and likeness in the future. So, with that, the questions that we're going to try to address tonight are: how did Michael Oher come to be under a conservatorship, and how typical were the circumstances of his conservatorship? Who actually does or should benefit from books and films that are based on a person's life story? How should people benefit under sports contracts? And how do the arrangements in Oher's case, to the extent we actually know what they were, compare to similar situations in which there wasn't a conservatorship? And finally, what role do sports and entertainment lawyers have in making sure that an athlete shares in profits when his life story is told, or her life story is told? Anyway, with that, I'd like to invite Rebekah Diller.
Good evening. So I'm going to kick us off by giving a sort of conservatorship 101 overview, and then we'll turn it over to my colleagues who'll talk more about the sports and entertainment law angles on the case. So what's a conservatorship anyway? It's something we actually don't hear much about until someone like Michael Oher or Britney Spears becomes affected by it, but it is a legal arrangement and process that affects about 1.3 million Americans. And it's often, as Professor Salzman said, also referred to as guardianship. So for example, in New York, what was Michael Oher's conservatorship would have been called a guardianship over the property. So I may use those terms interchangeably. But basically what it is it's a state court process where an adult can be declared incapable of making their own decisions, and the power to make those decisions gets transferred over to a conservator or guardian. And that conservator or guardian then has an enormous amount of control over the individual's life. How does it get established? It begins with a petitioner, someone who says this is necessary, who files a petition in court. And in theory, there's a very high standard before a court may appoint a conservator. In Tennessee, the way they express that is that the court must find by clear and convincing evidence, the highest standard in civil proceedings, that the respondent, the person who supposedly needs the conservator, is fully or partially disabled, and that the respondent is in need of assistance from the court. Now, in New York, we have a somewhat similar standard in what's called our Article 81 guardianship law. There, the standard is that you need to show that there's a need for the guardian to manage the person's personal affairs and or finances, and that the person is incapacitated. And of course, the law goes into more detail about that, but those are the general parameters of what has to be shown. There's another really important prong to the test in most states, and that's that in an acknowledgement of the significant rights that are at stake. So in most states, including in Tennessee and New York, the court also has to find that appointing the conservator is the least restrictive alternative, right? So there's this idea that there should be a really searching inquiry to see if there's some other way that the person's needs could be managed or that they might not be subject to harm before we take away such significant civil rights. In addition to these substantive protections, there's also a number of procedural protections that are supposed to happen. And so I'm sort of describing what the law says, and then I'll talk about what did and didn't happen for Michael Oher. But in most states, there's supposed to be, including in New York, an in-person hearing that the person who'd be subject to the conservatorship can attend. There's supposed to be a right to counsel at the hearing. And in Tennessee, they also require a report from a physician or a psychologist about the respondent's disability. In New York, we don't make that kind of medical analysis in our Article 81 system, but there is supposed to be in New York an analysis of the person's functional abilities. And then there's also typically, because again of the recognition of the significant rights, there's also supposed to be what in Tennessee they call a guardian ad litem, someone who's appointed to investigate the circumstances of this petition and report to the court. And that, which I'll get to in a moment, doesn't appear that that happened either in this case. So what Oher has said is that he was told that the Tuohy's lawyer was his lawyer. So there we have no guardian ad litem appointed, no independent counsel who could explain to him the situation, and his belief, according to his later filings, that he was being represented by that one lawyer. So what you saw in Oher's case is that despite these pretty significant protections that are written into the law. The order appointing the Tuohys as Oher's conservators, it doesn't say how they met any of these standards. In fact, it specifically says there's a finding that he doesn't appear to have any known physical or psychological disabilities. So it's incredibly puzzling how this order was even arrived at. And the order of appointment also says that it appears to the court that it's in Oher's best interest to appoint Sean and Leanne Tuohy as his conservators. So really the order does not follow the Tennessee statute in any way. And it's interesting because this reference to best interest is something you see a lot of in guardianship, notwithstanding language in the statutes that's supposed to really protect the person who might be subject to guardianship. There's a sort of sense of, well, okay, that's very nice, but we'll just do what we think is best for this individual. And that's really not what the law says. So what powers does this conservator or guardian have? Well, we often hear about two types of guardianship, one over the person and one over the property. A guardianship over the person may include powers to make medical and educational decisions. A guardianship over the property assumes responsibility for the person's financial affairs. And the important thing to remember is that once these powers are given to a guardian or conservator, the person loses them. So if I'm under a conservatorship and my conservator is supposed to be marshaling my property, I can't go to the bank and withdraw from my bank account because that right has been taken away from me and deposited in the conservator. And in Oher's case, we saw that he lost his right to make contracts without the approval of the conservators. The other interesting thing about what happened in his case is, and this is something we also see in way too many guardianships, is that the order appointing the Tuohys was of indefinite duration. So Professor Salzman talked about how when you look at the court docket, there's like nothing there for 19 years. There's this initial bit of activity and then nothing. And I think that points to the real danger of having these orders be of indefinite duration because no one's checking. The whole premise of this system is that someone is in need of some protection or assistance and you're taking away rights on that basis. And therefore, you've got to have some system in place to review how the arrangement is operating. Now, typically, in most states, including in Tennessee, the system for checking is the filing of an annual report, or they call it an accounting. And as Leslie said, there was no accounting filed during the entire duration of this conservatorship. Now there's a requirement that at the end that an accounting be filed, but it wasn't filed, and no one, I mean, it's kind of mind-boggling. The court never sent, it doesn't appear that anyone sent, any kind of enforcement order or anything to the Tuohys saying, where is your accounting? So that's a widespread problem that you see around the country, that while there's supposed to be some kind of monitoring through an accounting process and somebody reviewing accountings that are filed, it's unfortunately it's not that uncommon that accountings don't get filed and no one's really on top of it. And I don't know the particular situation in that court in which this case took place, but I'd be very concerned about anyone who's under a conservatorship in that court, because it doesn't appear that there's an active effort to monitor whether reports are being filed, much less review the actual reports that might be filed. The other thing I just want to note is one way in which Michael Oher's conservatorship was unusual was that he was able to end it so quickly. So he filed a petition to terminate the conservatorship, and that petition was granted rather quickly. It's actually often very, very, very hard to end a conservatorship once it begins. And, you know, this is something our clinic has done work on, even when the letter of the law says that it should be something that's ended quickly upon the request of the person who's under the conservatorship. It doesn't often happen that way. And there's often a very long, protracted process, and it's often very difficult for the person who's seeking to get out of the conservatorship to do so. And I'm happy to talk more about that in the Q&A. The one thing I'll just say is, you know, now the big dispute seems to be around the accountings. And the accountings is just the term of art for now. Finally, they're having to report on various financial matters connected to the conservatorship. So that's going to be something that my co-panelists will address further. But that's the technical mechanism that of why the conservatorship court is still involved in his case.
Thank you. So, Domenic.
Yeah, okay. All right, Robert Evans, the film producer, in his autobiography, The Kid Stays in the Picture, also a great documentary, by the way, says, there are three sides to every story. Your side, my side, and the truth. And no one is lying. Shared memories serve each differently. So I teach entertainment law up at Columbia at the film school for producers, screenwriters, and directors. And one of the things I say, first class, is curiosity is a superpower. So let's get really curious about what might have happened here. We're at a major disadvantage because we don't have the actual book contract and we don't have the film contract, but we can only deduce. But the good news is we do have the accounting. It's been filed with the court. So we do have some numbers, and we reversed engineer it, some of it. Alistair, sitting over there, helped me with some of it. Ellie Sanders, another associate attorney, helped me. But what do we know? We know Michael Oher made about $34 million in his professional football career. We know that the conservatorship was put in place in 2004, and that one day, this is what we know from the press, one day, we also know that Michael Lewis, who wrote Liar's Poker, Moneyball, The Big Short, and The Blind Side. Anybody ever read a Michael Lewis book? Anybody here? Great writer, yeah. Great writer, long form, great. So who's read the book, The Blind Side? Has anyone in this room actually read the book? You read the book?
I read it then. I didn't read it for this. I read it back then.
And who has seen the movie The Blind Side? Oh, wow, okay. All right, so this whole story, the reason we're here today came about because one day, and by the way, Sean Toohey, the father, and Michael Lewis were friends going way back. One day, Michael Lewis is visiting Sean Toohey and sitting in his kitchen table. And the reason he's there, he's in Tennessee, is because he's writing a story about college basketball. And while he's sitting at the table, he sees this kid that doesn't look like his other children working algebra with two of his kids. Who's that guy? What's going on? And he tells him the story. Great idea for a book. I'm going to write a book. And here we are. The Blind Side is published, and then the movie is released. 2006, the book, and then 2009, the film. So what do we know? What do we actually know instead of speculating? Well, we know that Michael Lewis has said that the option rights, life rights, are what you acquire if you're going to make a film. Underlying rights. You need the underlying rights. So in this case, the source material, the adapted material, the adaptation, the movie is based on the book, The Blind Side, right? So they need to pay Lewis something. And although you don't need to, technically speaking, because of the First Amendment and free speech, you don't need to pay anyone for their life rights. But the reason that it's best practice, you avoid lawsuits and entanglements like we're going to be talking about today, but also you have access. It's all about access, right? Personal stories, behind the scenes, what really happened. So the producers paid for that through Michael Lewis. So Michael Lewis was paid, he tells us, And why do we think this might be true? Because if you look at the accounting, the very first page, the first line, actually jives with this next point. He says $250,000, $250,000 paid for the underlying rights, which he splits 50-50 with the Toohey family, okay, half and half. So Lewis gets $125,000, and the Tooheys get $125,000. What do the Tooheys decide to do? They decide ultimately through the conservatorship to split that $125,000 5 ways. Mrs. Toohey, Mr. Toohey, their 2 children, and Michael Oher. At this point, is he even drafted at this point?
No, he was still in college.
High school. Okay. No one's famous. Now, it should be noted that very different situation from the Britney Spears scenario in that the Tooheys are independently wealthy. They later sell a bunch of Taco Bell franchises for $220 million. Okay, just note, just keep that in mind. So what happens next is, what happens every time, what people need to understand is those who take the risk usually take most of the upside. It's true in companies, it's true in business, it's also true in film. Rarely, and I've been in this, I've been a lawyer for 31 years, and I've been in this area for 21 years. I've never seen anyone make life-changing money off their life rights. I'm going to say it again. I've never seen anyone make millions from their life rights. Even famous people. The reason you want a movie about you to be made is so that you can go on a speaking tour, you can write a book. Oher wrote 2 books, by the way, which I'm going to be talking about. One in 2011. That's kind of been forgotten. Anyway, what happens next is the studios, as usual, work out a deal, not just for the agents in this case, CAA, reportedly the agents representing the Toohey family, work on a deal where, in addition to an upfront payment, which is typically a percentage of the going-in budget, and most people need to know the percentage of the going-in budget that is typically allocated to underlying rights or life rights is between 0.5% to 3%. That's what we're talking about. And the direct going-in budget that's based on, in this case, was originally $25 million, and the budget ballooned for $29 million. That we know, right? It's been publicly reported. So the $250,000 cap on the upfront payment is not unusual. What's also not unusual is a back end. Now, most people go, holy cow, $300 million this movie did at the box office. Where's my money? How come this guy is not swimming in cash more than the $34 million he made from his NFL career? Because Hollywood accounting doesn't give you a piece of gross, it gives you a piece of net. And guess what? To earn $300 million in the international box office, you do a hell of a lot of marketing. Those stars, Sandra Bullock and the others, got nice paydays, but typically the participants, the people that are described, even the writer himself, there would be no movie if Michael Lewis hadn't sat at that dinner table with his friend Sean Toohey. Even the writer makes a little sliver. So, what could have happened here? What might have happened here? So Alcon, the actual producers, say that they paid a total of $760,000 in total payments to CAA, to the Tooheys and Oher. This is what's called back-end payments, payments of the net profits. Actually, that amount includes the front end.
Yeah,
so,
that's all in, right? Yeah,
right, that's all in. So let's say then you take half of that amount, okay, half of that amount, you divide it by 5, and you get exactly what I see on that accounting statement that's been filed with the court, approximately $139,000. And I said, well, what if he'd have had his own lawyer? What if he'd have had an independent entertainment lawyer? Maybe, given his level of fame or anonymity at that point, he might have got, instead of a fifth, he might have got half. Because remember, the producers need to secure life rights from the family too, right? Yes, he becomes famous, he's more notorious, he's more known to the public, but remember, Sandra Bullock played one of the main characters, so you need the family's rights. So the total amount of underpayment, the better deal that he could have got, maybe $200,000. It should be noted that in the year after his team won the Super Bowl, Michael Oher made Yeah, made $6 million, just under $6 million. 17 games in the NFL,
Yep.
over 300,000 per game. Okay, so we're talking about, in the larger scheme of things, not a huge injustice when it comes to dollars and cents. It's wrong, but it's not to the level of like massive bank robbery. And the other side of the story, and again, who knows who's right, but the other side of the story is this. The Tuohys have provided to the court text messages where Oher has been saying last year, or previous years, you either pay me
It was started right after he retired, so it was like
right after he retired. You pay me 10 or 15 million, or I'll go to the press. And they put this money aside for him the whole time. And they said they would end the conservatorship at any time. Also noted that he wrote a book, Michael Oher did in 2011. And in the preface it says, "The Tuohy family, you've been truly a blessing to me. Thank you for helping turn my dreams into reality. But vision changes, recollection changes." And so what do we have? We have what they're saying, we have what he's saying, and we have the accounting. And from the accounting, I see nothing unusual about the way the money's divided. He might have got a little bit more, but also, typically, let's say you make a film, about 4 musicians, not called the Beatles, okay? You're probably going to divide their life rights into quarters. You're going to pay them 4 equal shares. That's what you're going to do. Even though 2 of them, John Lennon, say not called John Lennon and Paul McCartney, are going to be a little more famous than the other people. But that's what I have to say right now.
Oscars moment.
Yeah. I've been played off the stage.
Yeah.
Sorry.
All good.
So,
Take it from there.
sure. So I look at this, like I said, I'm a trial lawyer, and I get a little involved in a lot of disputes that are in the sports and entertainment space. And so, as Domenic said, what's really going on here? And Rebekah gave this great introduction and explanation of what a conservatorship is supposed to do and the purposes for it. And I think based on reading all of the filings in the docket and what they were trying to accomplish was that they were trying to fit a square peg into a round hole. So at the time that the Tuohys first met Michael, he was a junior in high school, and he was in the same high school as their children, which was a private high school, and he was struggling academically, and so they started to help him out, and then he was living with them, and he was a very good player. And the Tuohys were alums of Mississippi, and they have a very good football program, and they're part of the SEC. And so when it became apparent that Michael was going to be recruited and have the possibility to play high-level college football, and the movie kind of touches on this, one of the schools that he could go to is Mississippi, and Mississippi wanted him to come. But given a living arrangement and the fact that he was living with the Tuohys and had no family relationship or anything with them, that he would be declared ineligible under the rules of the NCAA at that time because he was receiving improper inducements from somebody considered a booster. And so they effectively took Mississippi off the table as a possible school for him to go play. So nobody wanted that to happen. And looking back, hindsight's always 20/20. I think somebody, and probably the lawyer and some others, came up with the idea as well. If we can get, we're not going to adopt him, but if we have control over him, he becomes, they were looking to either they were going to become his guardians, they were going to become a conservator, and they figured, and part of the reason why I don't think the court took a hard look at it to make all the findings, because the court did say in its 2-page ruling allowing the conservatorship that he was fine and had no physical or mental impairments. But if you look at the timing, they filed the petition in August of 2004, right at the start of Michael's senior year. It was granted in December of 2004, right before he would have been signing his national letter of intent. And so what they ultimately did was, I think, the conservatorship and the rights that it conferred to the Tuohys and allowed him to live in their house and basically take on all of the aspects of being their child, got them around the restrictions about him being able to play at the University of Mississippi. So, and then, as Leslie pointed out, nobody paid attention to this for the next 20 years. And even when you look at the filings and the complaint, I mean, Domenic just went through the economics of what their main fight is, and I don't, I agree with Domenic. I don't see a whole lot of extra money that's there. And so what they've really kind of grabbed onto is the notion, and kind of what the Tuohys should have been more vigilant but weren't, where they didn't fully appreciate the significance of the rights that were conferred on them by the judge, and they became conservators. And I think there's a little bit of revisionist history happening now with the Oher's, with Oher's argument and the lawyers saying, hey, wait a minute, you were a conservative, you were a fiduciary, you had all of these important obligations to look out for my client's best interests, and you failed to do that. You didn't file the accounting that was supposed to happen every year. You didn't protect his name, image, and likeness rights, which are important. And they're doing that through the lens of what's happening with name, image, and likeness of college athletes today, not through what was actually happening back then, because at that point, because he was a student athlete, the rules that were in place at that time prevented college athletes from receiving any money. If he had received any money based off of his name, image, and likeness, he would have been suspended from playing. And so nobody wanted that to happen. So I think the Tuohys never filed any sort of petition. But it also doesn't look like they were making any important financial decisions for him either, because Michael Oher had his own agent. He was negotiating his own contracts. He did have some endorsement deals when he was playing in the Baltimore Ravens and then the Tennessee Titans and then ultimately I think the Carolina Panthers before he retired because he had multiple concussions. But he had a very nice career. I think he even made the Pro Bowl one year. So he had a very nice, and he's got a Super Bowl ring. So, in terms of his athletic ability and his athletic career, he had a fantastic career. But I think what happened is that there started to become sort of some tethering and fraying of the relationship with the family. Once he retired, one of the things that the Tuohys were doing after the success of the book, and again, when this conservatorship was put in place, nobody had any idea that there was going to be a $300 million movie and there were going to be Oscars and publicity and even a book. None of that was happening at the time. This was because they didn't even meet Michael Lewis until 2005, and the conservatorship they applied for it was in 2004. So none of this was contemplated. And so when he graduates and he goes to Mississippi State, and then this movie blows up and everybody becomes a celebrity. And as Domenic said, you want to have your publicity out there because then it gives you an opportunity to go out and capitalize on it. It's kind of like how Usher and all the people that do the Super Bowl acts don't get paid. They actually sometimes even put their own money in because it gives them a market and publicity, and then they can go make money off of that after the fact. So, and that's the way the industry's set up. So there isn't a lot of damages that he's going to be able to claim and prove here. And so what they've kind of pivoted to is to say, look, the Tuohys, and particularly Leanne, they did two things. One, they established a foundation, which I think the movie studio gave a $200,000 donation to their foundation. And apparently they also offered to do one to Michael as well, but he didn't have a foundation and he didn't want the donation, so he never took it. But then she after the success of that, she wrote 2 books herself. But her books were, yes, it was sort of part of her family experience, and it was about, the importance of being kind to other people and helping people, and it was really more out of sort of like where her whole mindset and ethos came from. But because it involved Michael, and because it was sort of a more on the story that had become so popular, she made a fair amount of money on that. And if you believe what's in the filings, and again, this is kind of it's sort of what's been alleged and what's been responded to, and the Tuohys are kind of keeping their cards close to the vest on that stuff, and I don't blame them. but it's been alleged that, she made somewhere in the neighborhood of about $8 million off of her 2 books and some speaking tours and things like that. And in the course of that, she references Michael, and she talks about their life experience and him living with them. And one of the things that she often refers to him as, and the family has, is that this is our adopted son. And he's like, I'm not. And one of the things that he's argued now is like, you've sort of made all this money out there on your speaking tour telling a lie that you were saying that I was your adopted son, but you never actually adopted me. And you had all of these legal obligations because you were appointed my conservator, and where were you looking out for my best interests? And you've made $8 million telling the story that involves me, and I've gotten nothing off of it. And he's pissed. And I can understand why he's pissed, but I think he's got a pretty high legal hurdle to get over. And it's interesting, and I can kind of read through the tea leaves based on some of the things that have been filed. He filed his petition, and he made his arguments. They filed their accounting, which, as Domenic said, looks pretty accurate, but it doesn't include all the other stuff that, the other revenues that were generated from Leanne Tuohy's books and others' money that went to the foundation. And he's got one other piece in there saying that he gave $2.5 million, and it's unclear whether it was a loan or whether it was an investment into the Tuohy's business. And there's been no accounting on that and no explanation. And he's saying, what happened with that? Why haven't, something's going on. So all of that is now in discovery. One of the things, though, that happened this week, which was interesting, is the lawyers for Michael Oher put in and got a subpoena issued, subpoena ducis tecum served on Michael Lewis. And now they're going to go try to find out how much money did he make off of this. And it's, I think the argument that they're trying to get to is that, and as sort of Domenic pointed out, all these people made all this money. There was $300 million, and all I got was $138,000. Something's wrong with that. And on its face, yes, but as you go along and you follow the procedures and you follow the economics of the movie deal, doesn't seem that there's anything wrong with that. The argument that he's making that he is somehow entitled to some stream of the revenues that Leanne Tuohy made from her books talking about this, he's got an uphill battle on that because there's this concept of fair use, and the Tennessee statute that's in place governing this is you can't use somebody else's name, image, and likeness for advertising and promotional purposes, but that's not what she is using it for. She is out there telling her life story, giving her message, and it involves Michael Oher. And then the last piece of this, and you sort of when you get into this and the facts of it, they're starting to share some dirty laundry, right? So the text that came out that he started to send, and he was like, you need to pay me, and if you don't do this, and I'm going to go to TMZ, and I'm going to put a bad story out there about you. And they kind of kept it quiet, but now that they have to plead it, they're pleading it as, this is an attempt of a shakedown. Extortion, but I think he had filed a petition to and seeking an injunction that prevent them and prevent Leanne specifically and the website they have for their foundation of making any reference to him or using his name and referring to him as an adopted son. And they've since withdrawn that application, and he says, well, based off of what's been filed and what's been told, they understand that that's not going to be an issue anymore. And so I think what is happening is that hopefully, and if I were involved in this from either side, I would be advocating hard to get this thing resolved because nobody is, there's so much. I mean, there's a panel in New York talking about this in New York, and there's plenty of news stories that are out on this, and nobody is going to come out of this looking great, because certainly the Tuohys should have been more buttoned up in how they did it. And one last piece, just there's an ethical consideration here for the lawyer that represented everybody. There were different interests involved, and frankly, the court doesn't look all that good either. The court entered the order approving it, didn't really check through the statutory standards that were required of it. The court clerk, who's supposed to make sure that the accountings are submitted every year by a certain deadline. If they're not, then the court clerk is supposed to issue a notice and basically an order to show cause and come in. None of that happened for 19 years. And so, and then the other ethical piece of this is, and one of the other arguments that Michael Oher is making is that the TUIs, as as a conservator over his estate, they were kind of in business together. They were basically together to try to we're making money off of this, and they were partners together. Yet the TUIs were the ones making the decisions about how the money should be divided up and what was going on, and they had a higher fiduciary duty, and so they have an ethical issue too. And so this is all before the court. They've got discovery going for another few months, and then in theory, once the discovery's done, there's supposed to be a trial sometime within 90 days. I hope for the sake of the litigants that cooler heads prevail and they figure out a way to how to resolve this, because nobody's going to come out of this with unscathed from a reputational standpoint at all. And the only one that's probably going to make money on this are the lawyers.
Thank you. So we're going to move on in 1 minute to questions. First, some questions among the panel, and then we're going to open that up for questions from the audience. But before we do that, I have an obligation to say, for those attorneys attending today who wish to receive New York State CLE credit for our program, please record the following code: Blindside 847. In order to receive your CLE credits, you must report this code and any others that we give out on our online affirmation form that is found in the Zoom chat and on the Ticket Leap event page. Again, please record the following code: Blindside 84Z. That's Blindside 84Z. Okay. So, a couple of questions. So, you were talking about the negotiations when you have multiple parties, right, for these deals. And I'm wondering if you can talk a little bit about best practices. I mean, obviously, there probably should be multiple lawyers, but are there any circumstances where one lawyer could negotiate a deal for multiple parties, and what obligations would they have to counsel each individual with a separate interest?
Well, I agree with Keith. It raises all kinds of ethical issues. 2 words: conflict waiver, informed consent, explaining to the client that an independent lawyer may more zealously represent their interests in a different way, maybe getting more than a 1/5 share, for example. But it's not unusual at all to have a singular agency, CAA or WME, represent the rights holders, the underlying rights holders, when there's more than one party. Now, the issue is, how do you divide that? So CAA wants to get paid. They're going to bid this thing up as much as they can and try to get as much for their clients as they can, because that's their 10 or 15%. So in the terms of the total amount, I doubt they could have done much better. They might have done a little bit better, but not like shockingly better. Really, it comes down to whether it was fair to give him 1/5 or 1/2, the way I see it. But there's definitely an ethical issue there, I agree.
Right. And so, and on that, and I think you're right, but on that point, and it's an interesting one because, let's not forget, facts do matter. There is, in the discovery record and some of the interrogatory responses, that apparently, according to the TUIs, there was a family meeting where they discussed how are they going to divide up the proceeds that they were receiving, and nobody was complaining about the amount or anything like that. And I'm sure somebody involved and somebody at CAA basically gave the economic rundown that Domenic just gave, explaining to them about how much they're likely to see, and this is typical for how these things are paid out to the life rights holders. So, but there was a family meeting, and they all agreed, because there were the 2 TUIs, their 2 biological children, and Michael, those were the 5 stars of the story. They agreed to divide it up. They would each get 1/5. Now, one of the things that was in the filing, and again, this is coming back to why people aren't going to look good at the end of this. The Tuohys had given multiple statements about, and in their response, we gave him 1/3. But that doesn't really, there's a math problem there, and there's some, they, on the one hand, they've submitted responses saying that they all agreed that it was going to be 1/5, 1/5, 1/5, for all 5 of them. And then in their interrogatory, or in the accounting disclosure, they say that they gave him a full 1/3, which my look at is, I think it's a typo. Which again comes back to lawyering, but it's just a mess. But go ahead.
Yeah, there's one more point actually I have in the notes here. The Tuohy family had CAA negotiate, but Oher's agent in the deal is actually listed apparently as close family friend Deborah Brannon, an attorney who filed the same attorney who filed the conservatorship petition, and not a Hollywood agent. So it looks like Brannon may have gotten the percentage on the film deal for some reason. So, and wasn't Oher's mother also present at the conservatorship?
At the conservative
facts that
hearing.
get sometimes left out of the.
And I think, sort of getting back to why, when the court made the finding that this was in the best interests of Michael, without getting into all the standards and the legal standards of what does that really mean in the context of a conservatorship, if you just take a step back and at the 10,000-foot level, do you think this arrangement was in the best interest of Michael at that time? You'd be hard-pressed to say it wasn't, because he was living with them. They had taken them in. He became their child for the purposes of his ability to consider and if you believe the movie and in the book, he was drawn to Mississippi because of the ties that the family had, and they had gone up to. If you've ever been down there, if you've never been, I would suggest you go. It's fantastic. It's like this big college football tradition, and they walk out among the roses, and there's a big cocktail party, and it's just like this big traditional thing. And they had taken him up to see because they were alums, and so he liked it there. But he wasn't going to be able to play there unless they came up with some sort of solution. And so this was the solution, and in hindsight, probably was a pretty good deal for him at the time, because it allowed him to play at Mississippi and go pursue his career, which he did, to the NFL. But then nobody paid attention to it, and they kind of all forgot about it after the fact, including the court. And the problem that they have now is because, as Rebekah pointed out, these important legal rights that they took on, they really weren't exercising them in a responsible manner, and which opens the door to potential revisionist history arguments, and certainly Oher's argument that they weren't good stewards over his estate.
Thanks. So this is a question about life story agreements and the ability to control the story and its perspective and its content. So Michael Oher had said he was he was disturbed by his portrayal in The Blind Side because it didn't portray him as being very intelligent, and it didn't portray him as having a strong work ethic. And he felt that was wrong. And I'm wondering whether there's any way you can control, in your deal, when you do the deal for a book and you sell, there is an agreement over the life story rights. Is there any way to control how your life story is used? Like, is that ever done in contracts or?
Almost never. Almost never. And so I'll give you an example. I represented producers about 10 years ago. They wanted to make a film about an retired NHL hockey player from the 80s, had a great career, and was known to have undergone some serious cocaine use in the 80s, now born again. And he was insistent that he'd only agree to make the movie, give his life rights, if there's no mention of cocaine. You know what they did? They went and made another movie.
Yeah.
So if you made a movie about what happened to you today, it might be quite boring. No one would watch it. But if a Hollywood writer started writing a script of what you did today, it might be watchable. So that's why you never see this movie is a true story. This movie is based on a true story. because of artistic liberty. And it's absolutely imperative whether you're when I'm representing talent, I have to tell them, like, oh, do I get to approve? Well, what if I don't like a scene? You got to live with the risk.
Right.
And frankly, very few subjects that I've ever represented are thrilled with every scene. There's going to be something that they always object to. That didn't really happen that way. I didn't even know anyone like that. I never did that. Welcome to Hollywood. It has to sell tickets.
Right. I mean, at the end of the day, it's they're in the business to make money, and they're going to put out the story. Yes, your life and sort of the story generally provides a nice framework for what they want to put out, but there's you hear about it all the time. There's all kinds of things that they add to it just to make it more compelling and much more of a drama, and then it's going to be make it a better product as entertainment. So. Yeah, I mean, it's the same thing like when you meet with a journalist, or if you're going to sit for an interview. And I've got clients of mine that have sat for interviews. Who has final editorial review? Does the subject get to review the article before it comes out? Generally not. Almost never. And so it's you are giving up some license and creative control in exchange for having your story put out there. And if you're going to fight on it, as Domenic said, Hollywood, there's a million stories they can go tell, and it doesn't have to be yours.
Now, that doesn't mean that the film is not offensive. The film, by today's standards, may be considered very offensive, right? It does not age well. It did not age well. But that doesn't mean that a lawyer, if he had an independent counsel back in 2008 or whenever they negotiated the film deal, which I want to stress, we have not seen, wouldn't have said, well, I want you to depict him completely differently. They probably would not. I hear he comes out much better in the book, right? He's treated.
Yeah, the book
treats him much better.
Right.
And the other thing, I agree with you. I just want to say, this should probably have been settled and never been filed. It's very, very unfortunate. Family or friends.
So turning back to the conservatorship angle, this conservatorship was terminated quite quickly without. It didn't seem like there even was a hearing. It was just done based on the papers. And is that typical, or what's been your experience with terminations?
Yeah, so I think I alluded to this before. It's very atypical. So once you're under a conservatorship, there's quite a significant barrier to getting out of it. And there are a few reasons for that. First of all, often the right to retain a lawyer is taken away from you. And though you may retain the right to retain a lawyer with regard to your rights in the conservatorship, you don't have access to funds necessarily to pay for a lawyer. So the practical barriers, it wasn't the case in Oher's conservatorship because it was a more limited order, though, arguably retaining a lawyer is a contract that could have been considered to be under that conservatorship's powers delegated to the TUIs, but there are a lot of obstacles. So paying for a lawyer, getting your court file, getting your underlying papers that you need to demonstrate that either you've regained capacity or that you don't need the conservatorship anymore. And then there's also really a reluctance by courts to terminate conservatorships. They don't see a lot of these requests, and they often kind of take the view that, well, I don't know, what if something happens? What if we undo this arrangement and then the person, doesn't manage their finances in the way that we think they should, or someone exploits them. So there's a lot of reluctance by courts to grant petitions to terminate conservatorships and guardianships. And again, it's an area where on the face of the law actually is much more protective of individuals' rights than what we see in practice.
And to Rebekah's point and Leslie's point, the court, they had a preliminary status conference in late September, like a month after the petition had been filed, and I think we don't have the transcript, but essentially I think what happened was the court asked what was really going on, figured out that the conservatorship really was set up so that Michael Oher could go play at the University of Mississippi, and then nobody did anything about it for 20 years, and the Tuohys weren't objecting to it, lifted, and Michael Oher had his own agent, had been living his own life, financially independent for his whole life, and like, why is there a conservatorship here? And we're getting rid of that. The fight over, did they do their job when they were conservators, and is there a fiduciary problem, and is there an accounting issue and all that? That's still being litigated, but the conservatorship's out now.
Great. Thank you. So I just wanted to invite, I don't know if anyone in the audience has a question. Yeah. So if I could just ask you maybe, oh, okay, great. Okay.
Hi, my name is Vasia. Thank you so much for coming to speak today. I had a question about kind of the persistence of the Oher take on this situation, and I wondered if the name, image, likeness laws hadn't changed recently. Do you think that they would be, his team would be as persistent? Kind of how you laid it out doesn't seem like it's as much in his favor as we might hope. Do you think that if he did assume he could win on those issues and make money from those, do you think the case might look different, or if he never would have brought it up?
Well, as Domenic said, there wasn't a whole lot of economic upside that he would have been able to negotiate, even if he wasn't a college athlete back at the time. Like, those contracts are what they are, and the economics are what they are. What I think has happened here is his career's over. It was cut short by injury. He's seen his, the family, the Tuohys and Leanne make close to $8 to $10 million telling the story about him, saying that he's their adopted son, but that's not quite right. And I think he was upset about the way the movie portrayed him. And so I think he's just got a lot of, and again, I know nothing specifically about the case. It's just kind of me reading it and kind of understanding and been involved in other similar situations. I think he's just resentful about a lot of different things. And he also sees the Tuohys as being fabulously wealthy, and
Which they are. And if we think about it, if he were their son, he'd be one of three heirs to what's probably a $200+ million estate. So there may be some resentment there.
right, and he's not, and so right.
Yeah, but to your point on the book, okay, she wrote the book, Leanne wrote this book, but he's now written 2 books. It's interesting. In the first book, he mentions the Tuohys a lot, in the 2011, a lot. In the second book, he mentions them one time. So they would have arguments.
A cynic would say,
I don't think he's going to win that.
Yeah, I don't think he is either. And I think the cynic would say that, he kind of stirred all of this up again to coincide with the release of his second book. Cynic, not me, cynic.
I have a question. Who was managing his money when he was making money for the NFL? I mean, it sounds like the Tuohys were not.
No.
It
Highly
doesn't-
likely he had a
I'm
business
guessing-
manager.
Yeah, business manager, financial advisor. Most professional athletes do. They'll have an agent that will negotiate their contracts. Maybe the same agent or a different agent that would do endorsements, and then they usually have a financial advisor or a financial planner that'll manage their money. There's nothing in the docket that says that Tuohys played any role in that, other than the one claim he says that he had given Sean Tuohy $2.5 million, and there was no accounting for it. And was it a loan? Was it an investment in the business? There's some reference to that, but there's not a lot of detail about that.
Has that been substantiated in any way?
It's just in the pleading. They and the Tuohys and their lawyers, they're not providing a whole lot of information. Certainly not on the public docket. I believe they provided some information, in the course of discovery, but they're not trying to put out a lot of information on the public docket, and nor should they.
He's running out of money, number one, and it seems like he's a very good candidate for CTE, which is a very expensive. I'm married to a football player who's got.
Well, I'm on the board of the Concussion Legacy Foundation, so that's a very real issue.
A cynic would say that might explain the change in temperament.
And that's also
A cynic would say that.
that's a doctor might say that too.
A doctor might say that. A doctor might say that.
That's a fair
It's true.
point.
Okay, yeah.
This is a legal strategy question. Why is it that Michael is very comfortable talking about his case and kind of pleading his case
Well, he's claiming been a victim here, and he's been taken advantage of. So, he wants to get his story out there and point out all the ways where the Tuohys had taken advantage of him. And his best argument is the fact that the court appointed them as conservators and they had these certain duties. And, by all accounts, they weren't even doing the basic stuff of submitting the annual accounting and doing things like that. Nobody was pushing them for it, but they weren't doing it, and they had an affirmative obligation to do that. So he's trying to, and, if you look at some of the text messages and emails that were submitted by the Tuohys in response to say this is part of a coordinated effort on him to try to shake them down, an extortion, attempt to try to get money out of them. They have put that out there, but they're not putting out anything about the financial picture, their financial picture, how much money, Leanne made on her, books and her speaking tour, how much money they've raised through their foundation. They're not putting any of that out there.
Yeah. Which is not unusual.
Yeah, and I wouldn't change that strategy if I were them.
Just a quick follow-up. Is it normal that the defendant chooses to kind of be sort of silent and in the public eye, whereas the litigant is more aggressive?
Well, Marty Singer came out swinging when it was filed, Los Angeles entertainment lawyer. But I think Sean Tuohy, the patriarch, his original response was to say, he loved Michael Oher and he felt bad that this case was being filed.
Yeah, my typical advice to clients is you're not going to fight or win your case in the press, and
You got everything to lose and nothing to gain.
correct.
Right.
And because anything you say, you could come back and trip you up, and you're who cares? You're better. I said it's a much better storyline for you to keep quiet, win in court, and then that's the punchline, and there's no Google search will be out there forever. So the less that's said about it, the better.
Thank you for coming tonight. Just a question about whether or not the Tuohys ever opened a conservatorship bank account on behalf of Mr. Oher. I do a lot of conservatorships, and the first thing I do when I marshal assets is open a conservatorship account in my name as conservator. And so that's the first question. And the second question is whether or not the judge in the probate court in Tennessee was ever sanctioned for all of the lack of follow-up, et cetera.
Yeah, I don't know what happened to the original judge. I would suspect that there's going to be somebody looking into that. I don't believe that there was it doesn't, because what the Tuohys have basically said in their discovery response is that they haven't received any money on behalf of Michael, and if you look at the timing of the payments that came in, it was basically a pass-through for him for the first few years, so they would get money on a certain day, and then the accounting they submitted. But then toward the end, in the last few years, as there were smaller checks that were coming in, Michael refused to accept them and refused to cash them.
More recently.
More recently. And his point was, on the theory that he didn't want to make it seen as some sort of an acceptance of that. And so he wasn't cashing them. So what they did instead was they opened up an account under his son's name, and then they were depositing the check. So
Both.
yeah, so they opened an account under Michael Oher Jr., and then they were applying and depositing checks made out to Michael Oher into that account.
That part
Probably
is,
not best practices.
Yeah. Well, what is unusual about this case is for a high net worth family that you would expect to be buttoned up that didn't take certain precautions, of course, never expecting
Right.
this kind of blowback, probably.
We have time for one more question. Oh.
Oh, I didn't know if it's. I've never read the book. I've seen the movie a lot. It's one of those movies that, like, if it's on, I'll watch. And I'm sort of stuck on the adopt versus the conservatorship. At the time of the conservatorship, was he an adult? Was he 18?
He was 18.
Yeah, he was 18.
But they still could have adopted him, right? And in the movie, they make it seem like he was adopted. I mean, there's the scene there at the table. We want you meet, whatever. And I guess And
Hollywood.
I have read about this, and I believe his story was that they told him that they couldn't adopt him, and this was the only, if you, and I don't know, like I go to like, isn't that kind of like a fraud if you're misleading someone like that?
Well, that goes back to the ethical issue for the lawyer.
Right.
So the lawyer who was representing the Tuohys, Michael, and Michael's mother and submitted the petition on behalf of all of them. They all signed it, but the lawyer was representing them all. I think that there was another point you were just going to make.
About adult adoption.
Oh yeah, the adult adoption piece. That's right, because he was upset that they portrayed him as and that was part of the whole Hollywood thing that said he was adopted.
Yeah, and it.
I don't know if anyone else got that impression when I saw the movie. They adopted him. I mean, they never showed it, but you never heard the word conservatorship in the movie.
Yeah, that wouldn't
and
sell.
it bears.
But that wouldn't sell, right? That's,
It seems like it was hidden. That's. I'm a very suspicious person, but it seems to me it was.
Yeah, and it bears repeating. They're completely different things. This is what still doesn't add up about using the conservatorship for him to be able to go play football at Mississippi, which is that he didn't become a family member by becoming a conservatee. He became a conservatee, and they were his conservators. So whatever sort of workaround this was, it doesn't quite add up because he wasn't a family member through this process.
I guarantee you somebody spoke to the NCAA compliance officer at Mississippi and said, if we set this up, is this okay?
I'm sure, yeah.
Some
It's
conversation
just,
like that
doesn't-
occurred.
that makes sense, but it's
imputing,
totally different thing.
malevolent.
tool to
be-
accomplish what
Before,
they were
also,
talking
it should be noted, before we impute malevolent intent on the Tuohys or anybody, let's remember, at that time, he's just another college kid playing football. There's no guarantee he's going to be drafted. There's no notion that there's going to be a major Hollywood motion picture. So they think they're just doing something that's convenient at the time.
Right, and I think coming back to what I said before, they were trying to find a vehicle that would allow him to continue the arrangement that I think everybody was on board with, and all with the best intentions to give this kid a stable environment, give him a tutor so that he could qualify academically. Because remember, that was another issue, that he needed to qualify academically to be able to play, and he was in jeopardy of not being able to qualify. And so all of the intent around why they came together and did this, I think everybody was coming at it from the right place. The problem is that nobody paid attention to the details, and then they kind of forgot about it.
And that's a huge problem now.
And then nobody did anything for 20 years, and now we're looking at it through a lens of 20 years history, and you can feelings change, and now you can characterize things any number of ways.
So I'm going to thank our panelists very much. There's food and drink in the lobby, and if people have further questions, they can ask them then.